Address of respondent number 2. Therefore, Your Honor, for 4 weeks time may be given.
Item number 7.
Yes, Lordship. And there is an interim.
Now we have not taken any steps.
Your
No, in fact,
Lordship,
in this matter, Your Lordship, what has happened was that they have taken steps on many occasions through AD, through jurisdictional police station. Now, what the jurisdictional police station stated that gave a report that there is no person as such in that address. So subsequently, they have also perused the LCR where they have given the address, Your Lordship, in their GIMA application. In that address also, they have given the notice. However, there is no possible, I don't think there is any possibility of even, no one knows that that person is actually that person or not. The GIMA was taken through the GIMA and even through the documents that they submitted before the IO. Or in all the addresses, notices were issued.
So will it be possible on your part to trace out or to find out any proper address?
Lordship, we will try our best to find out the address. And
Let's
Lordship,
see then.
Hey, let's-
and Lordship, there is an interim that may be continued.
Is LCR is also been received that, no?
Yes.
Scan copy of it. Your good name?
MIP,
B.
MIP,
Not to listen, had so and so. Now, the petition also had MSTG, the Learned Additional PPF, state respondent. It is submitted by the counsel for the petitioner that the notice could not be served on the respondent number 2, even after best support. However, they will try their best to procure the proper and the correct address of the respondent number 2. And will take steps accordingly. Prayer along, the petitioner will accordingly collect the proper and the correct and proper address of the respondent number 2, and we will take the necessary step in issuing notice to the same. This time also, if you can collect the address, most probably you can send the notice to jurisdictional police station. Otherwise, if owned service to so and so will not serve. And after collecting the proper address of so and so, we take we issue notice to the so and so through the jurisdictional police station of the concerned. And let the matter be accordingly listed up.
deeply obliged.
Interim be continued till next week.
Ma'am, I beg to mention item number 3, ma'am.
Item number?
3.
Yes.
And that may be exempt to them.
The request of the so and so, let the matter be listed up to 3 weeks.
Your Lordship, I am for the petitioner here, Your Lordship. I don't know.
Oh, you're for the petitioner?
Yes, Your Lordship. Your Lordship, there is an interim order, Your Lordship.
Oh, you're for the respondent then?
Yes.
Yes, I am for the rest.
On 7th, this matter will be.
Considering the submission made by the Learned Council for the petitioner, Ms. TJ, the interim be continued till next.
7th, Your Lordship, 7th of August.
You want to fix it?
Yes, Your Lordship.
We'll do 7th of August.
Okay.
Deeply.
Let the matter be listed on 7th of August.
May I, Lordship, I beg to mention item number 8 and 9. Earlier, I was instructed to take press step. I have taken, but it's not reflected. That I have to check the registry. Your Honor. Or I may be allowed to take press step upon respondent number 2.
It is not reflected in the office note.
Yes. Though I have taken.
It is not reflected, then means the concerned section has not received the notice item. That will be the one of the reason why it has been reflected out. You are Mr. LK.
B type idea.
Mhm.
8 and 9.
Administration, so the Learned Council petition, also regarding STJ, the Learned Additional PP, appear on the state respondent. Notice, not yet, no notice issued on the respondent, not yet received by the consent section. Fresh steps be taken accordingly, let the matter be listed.
And Your Honor, for paper book, as LCR has been received.
Huh?
Paper book, it's for things. Paper book is not prepared yet, Your Lordship.
We can make it like that.
Yes, sir.
And it's the matter of the process and accordingly, the registries have a directive to prepare the paper book and to supply the copy to the registry.
Obliged.
Obliged, Your Lordship.
And Lordship, I beg to mention item number 11 and 12. As a leading counsel used to come from Guwahati, could not turn up today. 11 and 12. Mr.
Sitting council,
Mr. K. Boro.
Hmm?
K. Boro.
he for
M. K. Boro.
MK Board for
Yes.
respondent.
No, for petitioner and in item number 12 for respondent. Connected matter.
There are two RFA.
Yes,
এই দুটা উল্টা হব 11 for the MK Boro is for the appellant and 12 he is for the respondent. List after 3 weeks,
3 weeks. 3 weeks.
3 weeks.
Obliged.
Lordship, I beg to mention item number 2. Item number 2. This matter may be released after 4 weeks.
You are for the petitioner,
Yes.
the list of friends and list after 4 weeks.
Your Lordship, I would beg for item number 6.
Hmm.
For respondent advocate H.K. Jamo.
He is not available.
He is not available.
List after 4 weeks.
6.
6. List after 4 weeks.
Much obliged.
May I be your lordship? My lord, this is a quashing petition, my lord. Quashing of the criminal proceeding pending before the learned court below at Tejo. Can you see the FIR is page, my lord, 20 or 11 is 22. Basically, they have filed for a pet dog, my lord, family pet dog. And the case was registered under section 354 and 498A. Page 22. Your Lordship.
Case,
Page 22. It was alleged that, my lord, the petitioner number 2 has assaulted the informant herein, who is the wife of the petitioner number 1. And they have filed for there's some pet dog, my lord, in the early morning around 9 AM. And in her, the injury report is also there, page 23. It's very simple. And in her, my lord, deposition under 164, the 11th portion, your lordship may find, page 30. Page 30, last paragraph, my lord. Type copy. Last paragraph, may I read, my lord? This. Then on 3/3/2021, I wake up and found that our pet dog was biting my supple. Then I took away my supple and hit the dog, but not so hard, scolding it why you are biting. During that time, Jitu Maru, my brother-in-law, passed through the area and pushed me aside. I told Jitu Maru as to why he pushed me. In this way, our argument started and there was a fight in between us. As a result, I discussed on his body parts during which one what is missing. Meanwhile, I also got cut in my leg while Jitumaru pulled my hair and threw me aside. Later, after hearing the commotion, my husband woke up and came out. He was slept. It is said the husband slept, not the petitioner number 2. And slapping me and even with my bleeding in leg. During that time, Jitu Maro videographed me trying to threaten me wrong so that upload the video in social media. As I was injured, I was taken to hospital by my mother, brother who arrived at the place of occurrence after they informed by one cousin to whom I called over phone to inform them accordingly. My husband did not bother to inquire about me. After I was taken to hospital for treatment, I went to police station to lodge a complaint, but before lodging the complaint, my brother called Jitu Maro that we were to lodge complaint in the police station. As there was no response, accordingly, we lodged complaints against the Jitu Maro. Thereafter, my husband could also arrive at police station when called by the police, and Jitu Maro was in hiding. My husband insisted, instead blaming me and intended me not to lose FIR. If did, he would not keep me as his wife anymore. This is the allegation, my lord, main allegation. This is basically, my lord, within the family members. That's why, my lord, now says notice has not served, my
Your lordship, this case is completely devoid of merit, your lordship. Why I'm saying so? The 482 application for quashing, your lordship, has to be exercised sparingly with circumspection and exceptionally in rare cases where it is patently clear that the complaint is a frivolous one or do not disclose any offense. Now, my learned brother had already submitted that she has sustained simple injury, which
No,
is
there is-
punishable under IPC, your lordship.
my lord.
Whether it is between the family or not, that is immaterial for at this stage, your lordship. Whether a prima facie case is made out or not, that has to be considered for exercising power under section 482, your lordship.
My lord, what is
So-
the ingredients of 498A, my lord? But where is the willful intent? There is no willful intent. It was happened suddenly.
And your
It is
lordship,
not the planning, the pre-plan where there is a demand, cruelty. That is not there. There should be a willful intent. Well, to prove 498A, there should be, my lord,
Haven't taken steps till now?
no, my lord, notice has not issued.
No, the issue.
and your lordship, these are the disputed fact which has to be raised before the learned court below during the consideration of charges, not before the High Court, your lordship. The matter is 164 statement, everything has been recorded. Perhaps, your lordship, the matter has been charged sheeted, your lordship. So,
Matter has been started. That's why we are filing this 498 for quashing of the proceeding.
your lord,
It was started. I have appeared also. This
your lordship, since this is a
my lord,
482,
intent of this one, ingredients of 498A is not there. There is no willful intent. There should be a willful intent.
the question here is, your
To prove
lordship,
the quality.
whether
And for 354, there should outrage of modesty. There should be, my lord, decency of the woman would be there. That is not there. That's why we are before your lordship. Plus the notice maybe go,
your lordship, this on page number 23, the injury report has been annexed, your lordship, simple injury, which is punishable under IPC, your lordship. If we, your lordship, even if it's a family dispute, your lordship, the husband or the family, they don't have the authority to assault the daughter-in-law or the sister-in-law, your lordship, or even the wife, your lordship. This, in fact, this annexure 23 is itself, your lordship, disclosed that the offense has been committed, and your lordship, and to exercise the 482, your lordship, it clearly it is no more res integra that, your lordship, the prima facie case has to be looked into. And your lordship, at least at this stage, your lordship, the court has to see whether the prima facie case is made out, or your lordship, on the basis of, your lordship, the material collected by the investigation authority, which warranted the accused to be tried, your lordship. So, your lordship, I would like to rely this Supreme Court judgment, your lordship, on that aspect, your lordship. And your lordship, the disputed fact, your lordship, this they are saying that whether the ingredient is attracted or not, that has to be apprised before the learned court below by invoking, your lordship, section 239, 227, or 245 S case maybe, your lordship, but not before the High Court, your lordship. So, Your Lordship, I will just rely this judgment which is reported on 2023 SCC online SC 379 from para 9 to 12. May I read, Your Lordship? Having gone through the impugned common judgment and order passed by the High Court, quashing the criminal proceeding and discharge the accused, we are of the opinion that the High Court has exceeded its jurisdiction in quashing the entire criminal proceeding in exercise of the limited power under Section 482 CRPC and or in exercise of the power under Article 226 of Constitution of India. From the impugned common judgment and order passed by the High Court, it appears that the High Court has dealt with the proceeding before it as if the High Court was conducting a mini trial and or the High Court was considering the application against the judgment and order passed by the learned trial court on conclusion of the trial. As per the cardinal principle of law, at the stage of discharge and or quashing of the criminal proceeding, while exercising the power under Section 482 CRPC, the court is not required to conduct a mini trial. The High Court is in common impugned judgment and order has observed that the charges against the accused are not proved. This is not the stage where the prosecution or investigation agency are required to prove the charges. The charges are required to be proved during the trial on the basis of the evidence laid by the prosecution investigation agency. Therefore, the High Court has materially erred in going in deal in allegation and the material collected during the course of investigation against the accused. And at this stage of the charge and while exercising the power under Section 482 CRPC, the court has a very limited jurisdiction and is required to consider whether any sufficient material is available to proceed further against the accused, for which the accused is required to be tried or not. One another reason pointed out by the High Court in that initiation of criminal proceeding is malicious. At this stage, it is required to be noted that the investigation was handed over to the CBI pursuant to the direction issued by the High Court. That thereafter, on conclusion of the investigation, the accused person have been charge sheeted. Therefore, the High Court has erred in observing at this stage that initiation of criminal proceeding is malicious. Whether the criminal proceeding were malicious or not is required to be considered at this is not required to be considered at this stage. The same is required to be considered at the conclusion of the trial. In any case, at this stage, what is required to be considered is a prima facie case and the material collected during the course of investigation, which warrant the accused to be tried. In view of the above and for the reason stated above, when the High Court has exceeded it in its jurisdiction in quashing the entire criminal proceeding and applying the law laid down by this court in getting of decision on exercise of power at this stage of discharge or quashing of the criminal proceeding, the impugned common judgment and order passed by the High Court was and said. So, Your Lordship, the material whichever has been collected is clearly annexed in their petition, and that injury report itself is sufficed that the prima facie case is there, Your Lordship.
We want to argue the matter, or we can, if not, issue the notice.
No, only notice may apply, sir.
SK Deori,
Yes, ma'am.
Mr. SK Deori, the learned counsel for the petition, also had this regulated. The learned additional quickly appearing on the report. State respondent. Issue notice to be responding private. Now, how many private respondents are there? Two or one?
One, ma'am.
Or for the scan copy of DLC and this matter according to the. So you text it.
Yes, by register post.
In meantime, we'll call for the scan copy of DLC.
Applies to
Yes, Your Lordship, since there is no any impugned or there is no any order of stay, Your Lordship, it may be clarified in the order that dependency of this case will not have any impediment to Lionel Court Bureau to proceed with the case, Your Lordship. Yes, Your Lordship.
Applies.
Deeply obliged.
My lordship.
Item number 50.
Yes.
Item number
15
15
and
and 16 can be taken together, arising out of same.
Same FI.
15 and 16.
15 and 16.
Yes. My lordship.
I cannot say one is BA.
No, 302.
Both are BA. madam.
Yes.
BA. BA.
Oh, both are bail application under 439. Yes.
Oh, sorry.
And arising out of same FI.
15 and 16.
Yes. In fact, lordship,
This is the third successive bail application. The first bail application was filed before the sessions Pasigat Ischia on 10/7/2023. And subsequently, by order dated 13/7/2023, the bail application was rejected. And second bail application was filed on 21/7/2023. And the same was rejected by order 23/7/2023. Lordship might take you to the FIR, page number 24. May I proceed? It is to inform you that today, that is on dated 7/7/2023, at around 6:47 a.m., my wife got information from one Sri Sasansaj that one Sri Sasansaj told him from mobile phone that my son, namely Sasansaj, is about 17 years, found dead with multiple head injury near Beer Bar Pane Hotel, Baskota, Pasigat at early morning on dated 7/7/2023. It is pertinent to mention here in that yesterday on dated 6/7/2023, my son was accompanied with Sri so-and-so, were arrived at Pasigat from Alo for selling of lottery ticket at Pasigat. I am very much doubtful that the above name, Sri so-and-so, might have killed my son. Therefore, your honor is requested to take immediate action against them as per provisions of law. This is the FIR, Lordship. Lordship, the brief fact of case is that the alleged accused person and the victim deceased have known each other from last 7 years. And all the alleged accused person and including victim were proceeded to Pasigat from Upper Siang Yingkyong on pretext of selling lottery ticket together on 6 July 2023. And at around 8:30 p.m., all the accused person and the victim deceased arrived at Pasigat and checked into the hotel MA at around 8:30. After that, they went to the beer bar at Pane Hotel, top floor of the Pane Hotel. There is a beer bar called Comics Beer Bar. And they were enjoying drinks together. There were three accused, and one of the alleged accused, after 10 p.m., they requested their friends, this accused person, to drop them into the hotel where they have stayed. That is Hotel Ame. And accordingly, their friends took one of the accused person to the hotel, to the hotel by the victim and alleged accused person. After that, they returned back to the same beer bar, their comic beer bar. Then, after their returning, the present alleged accused person, they went to the cash counter to pay the bills of the beer bar. And after paying the bills, when they turned back, one of the staffers of the bar told the accused person that one of your friends have laying on the ground in unconscious mode. Then the alleged accused person, along with one of the alleged accused person, one of the applicants in the BA number 16, item number 16, they too went down the stair along with the manager of the hotel to see whether the person fell unconscious, laying unconscious, is their friend or not. On arriving down the stair ground floor of the hotel, they found that the victim deceased were laying unconsciously. That is the fact of the case. And thereafter, the victim were taken to the Bakinpattin General Hospital, Pasigat, by the alleged accused person himself, along with the other members of the hotel. And they were kept in the emergency ward at the Buckingham General Hospital, Pasighat, by the victim, by the alleged accused person, wherein the police engaged in the duty informed the police station Pasighat, OC Pasighat, and thereafter the police personnel and the police authorities arrived at the General Hospital Pasighat, wherein by that time, after 30 minutes, the doctor attending the victim were declared the victim dead. This is the story and this is the fact brief of the case. And thereafter, again, the alleged accused person, he himself went to the Pasighat police station to inform the incident in written along with the other accused person. They voluntarily went to the Pasighat police station, wherein they have submitted one written report about the incident. But however, that report was not registered. And during course of time, the police authority have suggested them to remain inside the jail, in because of that there might be a law and order situation, since the alleged accused, the victim was a local community belongs from the Adi community. So the situation may exaggerated. On pretext of that only, the alleged accused, all the alleged accused, three alleged accused person were asked to remain inside the jail. After that, they were formally arrested by the police authority. This is the fact of the case, Lordship. And thereafter, the bail application was filed and the last bail application was filed on 21, and that bail application was rejected by order dated 23/7/2023, stating that, may I take you to the page number 31, Lordship? Second para, Lordship. Page number 31, second para. This is the observation made by the IO, and this is the comment of IO. IO of the case has submitted the status report, but it has not revealed any completion of the investigation. But it has reported that the accused is not required for custodial interrogation. This was the report submitted by the IO of the case, Lordship. But the learned court below, while rejecting the bail, has observed that, may Lordship, para 5. In absence of any such specific report from the IO, this bail application is not covered under successive bail application. No new grounds has found to be established. Therefore, the IO is required to make objection and comment specifically to determine as to whether the application could be allowed under the purview of successive bail application. Accordingly, the bail application is rejected at this stage and stand disposed of. Only on this ground, the bail application was rejected. Now, the alleged accused person are languishing for last 21 days since his arrest.
This matter is listed for the first time, my lord. We'll call for the case directly.
In the meantime, most probably there may be some progress in the investigation.
Yes.
By that time. Let us see the court case.
There's a case for 302, my lord, there must be.
Yes, matter of 302.
May I? So, Lordship, here our one of the major ground is major ground for finding this application before your lord. That the learned court below have failed to appreciate the fact that it is clearly reflected in his own order, saying that their custodial interrogation is no more required. Spite of that, our bail application has been rejected.
In 302, my lord, even the custodial interrogation is not required, my lord. That is not of much
Yes,
significance, my lord.
my friend has already narrated the entire fact.
Yes.
So merely on the basis of suspicion, we were arrested. We are friends, Lordship. We are having drinks after a long tired journey. We are having drinks and he went missing. And when we tried to figure it out where he is, we found that he was in the unconscious state in the downstairs, whom by the restaurant owner himself. And we took him to the general hospital.
It's on, my lord, Wednesday. We'll argue on that day, Wednesday.
Matter of Wednesday.
Wednesday, too.
That is in second.
Second of our state.
Voting matter will be stated on CDV call for. Let's see about the report from the IO. And one more thing is one CCTV footage is not yet received by the IO from Guwahati. Most probably it has sent to Guwahati for analysis. That has not been received, I think by the trial court below or either by the, not be collected by the IO. So CCTV footage may help us, may help the investigation if there is any position in that.
And right.
So CCTV footage, we can pass an order also. No? City corporate and further the IO is hereby directed to collect the analysis report of the CCTV footage. If any. This can be, if this any CCTV footage that can be collected. or it can be-
By this time though, I am hopeful that
Maybe.
they might have gone through the.
Yes,
CCTV
maybe, maybe. Okay. Wait is what.
Deeply obliged.
footage.
Seventeen is not. there.
Item number 17, the council has called me that they are on the way and this matter may
Yeah,
pass on.
timely.
Yes.
Time it. Yes, you are on item number 4.
Yes, 4. This is a lordship compounding of non-compoundable cases.
For the absent.
279 IPC. There are three sections, 279, 337 and 338.
Hmm.
And 279 is rash and negligent driving.
Yes.
Due to rash, as per the allegation, due to rash driving this, as per the FIR section, page number 12. May I read the contents of FIR? With humble respect, I have the honor to inform you that your necessary to that. Sir. On 11 February 2019 at 12:15 PM, scooty bearing number such and such, radar name Ajan Lukam. This is the petitioner of Notco village of Datchong, POPS Kanawari, near DDSC office Longting hit a 4-year-old boy named Wangsha Wangshu, the son of Powang Wangshu, of such and such address, while going with his mom to general ground, Longding. That's as per the mutual understanding, the first party, that is the accused person, this present petitioner has agreed to go for complete treatment of the victim, but after reaching Kanawari, they turned away by having simple checkup done at Sonari Private Hospital. But as per doctor prescription, the patient was to get CT scan, but they refused to do so. That's I had submitted FIR earlier on 15 February 2019, which was not registered again as per your direction. I am submitting the same on 25 February 2019. This is the case. So after this, this accused was charge sheeted during the course of investigation under section this I have mentioned this 3 section. Section is 279, 337, 338. 337 and 330 is a compoundable offense, and 379 is non-compoundable offense. However, it is a motor accident cases, and petty offense punishable up to 6 months. In this case, we have this victim family and this accused person has entered a mutual agreement. And page number 23, by executing settlement compromise deed on the 5th of September 2021. As per this settlement agreement, the first party, this accused person has paid a sum of rupees 40,000 to the second party for medical treatment of the child who got injured. And there was no major accident with the victim child by causing grievous injury. Therefore, the complainant and the family do not want to proceed the case against the accused before the court. That is the settlement arrived at by the parties. So after this settlement, the matter being non-governable offense, which is not within this 320 CRPC compounding, not within the compounding power of that trial court. So this application has been filed under 482 for compounding of non-compoundable, particularly that 279 section. Since there is no problem from this victim side also, and they do not want it to proceed, and I also want not wanted to continue the case since I'm the victim. That is why taking into consideration of the matter, this this matter may be with the power of the court, matter may be compounded for the interest of the party to secure end of justice of the parties. This is my prayer before this matter may order may be passed and petition may be allowed.
Lordship, yeah, Lordship, settlement is okay, but Lordship, this agreement is disputed, Lordship, because as per this agreement, Lordship, may see the agreement page 24.
30.
24 page,
Yes.
petition copy. Yes.
Hmm.
This point 2, Lordship, that the settlement has arrived at because accused first party herein above has paid a rupee 40,000 only for medical treatment of the victim child, and there was no major accident with the victim child causing grievous injury. Therefore, this complainant and the family do not want to proceed the case against the accused before the court. That is their Lordship. But if you go through the Lordship, the statement of the father, Lordship, victim father, is in page number 19. Yeah, Lordship, this victim father is totally denied that Lordship, they have made any promise and they have bear the expenses. Lordship, in this statement, Lordship, may I read, Lordship? I am to state that on 11 to 19 at around 12:15 hours, scooty bearing registration number this driven by one Sri Ajan Longkam, son of this and hit by my son Sri Wangsan Wangsu 4 years near the registry office Longding. When he and his mother was going towards general ground Longding, the accused was recklessly driving the scooty, and later he had promised to bear the expenses for treatment of the victim, but he did not keep his promise. Therefore, I had to no option to take legal action. So, Lordship, here, Lordship, in this petition also, Lordship, on dated 24/9/21, the proceeding was stayed on the ground that the petitioner has to file affidavit confirming the payment, but that was never done, Lordship.
Well,
The page 24/9/21 order, Lordship.
Twenty-four nine,
Yes, Lordship.
21.
21. This petition is Lordship pending since a long time, just because Lordship they have asked to file affidavit confirming the payment, Lordship. The posting was also been staged since then.
Twenty-four nine, you are on 24/9,
Yes, Lordship.
2021.
Yes, Lordship.
In 8/21, then 7/9/21, then Charles, former Charles Reid, then 17/9/21,
24/9.
then 20, again then 19/10/2021. I would have a presentation it was missing, I think. Now what is written there on 24/9?
24/9, Lordship, in our records, yes, sir. In our records, Lordship, we have not down the all the judgment or the orders, Lordship, in our file, Lordship. It is noted here that 24/9/21, the proceeding was stayed. Lordship, this
Your-
Lordship LCR, because I'm talking about High Court, Lordship, High Court
Oh,
order.
High Court order.
Yes, Lordship.
I thought yours was LCR.
Lordship, it is clear in the page number 12, FIR itself reflected. This,
So did the 24/9, no?
Yes, Lordship.
What's the first order?
Lordship. The payment was done, Lordship, and this, all the Lordship, this, there,
Then do you have any receipt? Then it was a clear order on the 24/9.
actually, kindly see this
No, no,
matter.
see is a different
Page
thing.
number, this is,
No, question is that the court have passed an order that if you have already paid the 40,000,
yes,
then just pay the thing, receipt and all. So you're avoiding that?
no. Actually, this
Just
settlement,
pay the receipt and
settlement
then
was,
we go.
settlement was done on 15 September 2021. And FIR was lodged on kindly see Lordship. FIR was on 11 February 2019. And settlement is 2021 method. It was 19. This accused, this victim father has given 161 statement before the police on 11 February 2019 itself. And as per the FIR, kindly see, it is completely reflected. He has said that.
No,
Yes,
I have already
yes,
understood
yes.
that the FIR was lost because they did not bear the expenses for the medical
Yes, yes.
expenses. So thereafter, they lost the FIR. So immediately after lodging of the FIR, the statement of the father was also recorded.
Yes,
Wherein he said that no, they have not provided any money for
Yes.
spend and all. And thereafter, you have entered into an agreement,
yes,
and where it is written that you will pay the 40,000 rupees.
yes,
And in the entire agreement also, we have written that there's no grievous injury, otherwise, but there was a grievous injury because 330 has been registered and charged also. Now, we are on the order passed by this court on 24/9, wherein you are directed that you will file an affidavit in that regard,
yes.
that you have filed the affidavit and you
Yes. Habla.
Lordship, next date, Lordship.
had we are on 4/9. Had Mr. Itappa did an counsel for the petition and also had Ms. Haki did an CPP scan copy of the essay had already been received. However, for first still received. And as per the settlement agreement, it has been stated that the this 40,000 has already been paid to the parents of the victim child. And I had ordered it 24/9/2021. This court that directed the petitioner to submit an affidavit regarding the payment of this 40,000 to the parents of the victim child. But till date, the petitioner failed to produce any affidavit in that respect. To stop, the petitioner is accordingly asked to submit the affidavit as in pursuant to order dated 24/9/2021, and letter will be listed accordingly.
Habla.
You want any specific date or to submit it 3
after-
weeks
No, after 4 weeks.
after 4 weeks, that the matter will be listed accordingly. It was a simple direction that you
Yes.
pay an affidavit that you have paid the 40.
Earlier occasions, I have tried to call all the, this party
Mm.
petitioner.
They try to
but,
contact the parties and
Like,
it's item number 5.
Yes, Lordship, if I may. Lordship, firstly, I would like to apologize. We were directed on the last occasion to take steps, but as due to the ensuing vacation thereafter, steps were not being taken, Now, Lordship, I have another prayer for consideration, that although we are directed to take steps, already on 2 occasions, prior to occasions, firstly on 2/3/2022, a similar attempt was made through the police station of Nahalagan, wherein a report has come back saying that the respondent is not at the address given address. Then again on 7/7/2022, a report was, another attempt was made to serve the notice to the CJN. But same, it came back stating that the person, the respondent is not staying at the place mentioned given in the address. Now, Lordship, this address was obtained by us through the application that the respondent had filed before the learned CGM court. So this was the address he has used for this during his Jimma application. So now he is not being found in this address, and we have been taking steps. So this matter was first heard on 2/11/2021. Since 2021, this is at the stage of notice because it cannot be served upon the respondent who is not traceable at the address given in the lower court records, Lordship. Even through the police, we have attempted, Lordship, it is the same, Lordship. It is not going through, Lordship.
Serious in nature.
Lordship.
Presence of the respondent is required. So,
Actually, Lordship, if I may, Lordship, the issue here in Lordship, even if supposing this petition is allowed, we are only seeking liberty that we may be allowed to approach the learned CGM court to stake our claim. So this, even if this petition is allowed,
set your claim.
actually, Lordship, we are the insurance company. So what happened was that some Fortuner vehicles were stolen from Delhi and they were sold here. Now it is on record that the person who has the respondent number 2 herein, he has purchased this stolen vehicle. It is on record. However, at that point of time, as we are not aware, so we could not come here and claim the vehicle. So accordingly, he was using the vehicle. So the learned court had given Zimma to that person on indemnity. So now,
Basically, you are in the original case, you are the accused.
oh no, Lordship, I am the insurance company.
No, no,
You
in
are
fact,
the
in
insurance
fact,
company.
in fact, it was, the insurance company, Lordship.
Hmm.
With regard to the owner of the car who is from Delhi, his car was stolen. And the Zimma has been given to the accused, who was using the
Accused
stolen
means the
car.
respondent number 2.
Yes, respondent number 2, who was using the stolen car, Your Lordship. Now, firstly, the lower court has, the trial court rejected the Zimma application. Subsequently, they went to the district court, sessions court. Your Lordship.
Jimma was allowed.
Then Jimma was allowed. Your Lordship. Now, they are challenged, the main contention of there is that they may be allowed with the liberty to approach the appropriate court.
With a fresh Jimma.
Yes. Now,
Okay, then otherwise, from the facts of the case, it is said that even in absence of
Yes.
the sum up to can be decided or order can be passed.
yes,
But the question is that the court and bench most probably will pass the order to take steps. So complying the order of the court, we just take up fresh steps in this regard. Let us see if the same position is that definitely an order can be passed from the considering the facts and circumstances.
yes.
I thought you were the accused in the cases that did raised under 465, so and so, so I thought you were, anyway, you are the company. actually.
Yes, Lordship.
Okay, then that order can be cited, otherwise, could have been, order can be passed today actually, but the question is, then one order has already been passed
Yes.
directing you to take steps, so that means.
Lordship, then we may again be allowed to take steps through the
Yes, yes,
concern.
that's what I'm
Also.
saying, because order has been passed. Had Mr. Sukhdeep Dalal, the learned counsel for this so and so, and also had Mr. MHG Jain, the learned TGN, the learned counsel for the learned HCP for the state respondent. From the office note dated 26. Yeah, proper office dated date is missing. From order. from
16,
the
6,
order
Lordship.
of from the office note, from the office note, it revealed that the first steps is not yet taken to the respondent number 2. As per direction of this court, and accordingly, the petitioner is hereby asked to take first steps on respondent number 2. This time, in the last occasion, 2 occasion, you have taken steps to jurisdictional police station also.
Yes,
Yes.
Lordship, it was through the CGM also it was attempted,
The
Lordship.
person may be,
In fact, this will be the fourth time that they will be issuing not
yes,
steps.
yes. Submission, you would have made the submission, this kind of submission earlier in the before this court, then most probably it would have been decided. Anyway, so you, this time also you take, otherwise I don't think the other sources will help you.
Yes,
So take the jurisdictional police station only, let us see. what happens.
Keep your-
Much of it.
Now car is in Jimma with that person only. but
He's
still,
using the person. He's using the vehicle, Lordship. Much of it.
List of the police. Yes.
May I please, my
but
lord?
then
My lord, I am for the respondent.
For the respondent.
Yes, my lord. My lord, 3 weeks time may be given to file affidavit.
You want to file affidavit in opposition?
Yes, my lord.
You're appealing for L permit and you also what good name? Your number is
Lordship. S. Iram.
Huh?
S. Iram.
Heard Mr. S. Development Council for you for the petition
Yes.
and also heard. Yes.
And Sora.
Yes. Huh?
Nyali Sora.
Oh, and Sora.
Yes.
So they submitted by the London Council for the respondent that he needs 2 weeks time. To
2
file the
weeks.
affidavit. 2 weeks time,
Three.
3 weeks time to file the affidavit in opposition. Prayer allowed. Let the matter be listed after 2 weeks. In the meantime, the respondent will file their affidavit for opposition. Serving and copy to the other side.
Leave double.
And your will.
Lordship, in this matter, on 19/1/2023, your lordship will see the order of the court, your lordship. I had
19-1.
19/1, the last order. I had apprised the court on that occasion that the victim,
My lord, this is an appeal against conviction, my lord. My judgment and order dated 23/3/2023. The appellants herein convicted for 7 years under section 17B of NDPS Act. Yes, my lord, there are my lord, only 6 witnesses, prosecution witnesses are there. And there is a vital lapses in the part of prosecution. The section 54A was not complied by the prosecution
54A or 52A?
of 52A.
Hmm.
There is no inventory increased by the IO.
There is a total non-compliance of 52A.
Yes, my lord. And this is regarding seizure and sampling of the contraventions. And secondly, my lord, this vital witnesses who did the search and seized the articles was not examined. She was the lady constable,
So
called
none of the seizure witness were examined?
not examined. Yes, ma'am. This is the lapses. Ma'am, kindly see the FIR. FIR is in page 19.
19.
Yes, madam. May I read, madam? I have the honor to inform you that I have received the information from source that 2-3 ladies who used to supply opium within Rowing Township area likely to be reached by Teju State Transport. It is also informed that they were having huge quantity of opium along with them for supply to their customers. On receipt of the information on today on 12/6/2015 at about 10:30 hours, I comprising with ladies, police and staff went to the transport office complex and could name 3 women disclose their names as Batanshu Rai, so and Songsi Pro and Shrimati Thongsi Bengia. There is a three lady. This line is important, madam, last line. During search of their belongings by Lady Police ASI Ardas and Constable P. Wang Pang, she is also lady, a huge quantity of FM-like substance with about 20 grams of in total recovered from their possession and seized at a spot maintaining proper procedures. These two lady officers were not examined. Only the IO, who is PW2, he says it was seized from the possession of the appellants. And in the seizure list also, or in the search sheet also, this lady was made as a witness. This lady, page 39. In the search sheet, this is the type copy. She was witness number 6. She was witness number 6. She was dropped. She was dropped by the prosecution by order dated my lord 24/1/2018. It was said, my lord, she is not a vital witness. That her evidence is not so materials to establish the prosecution case. It was dropped on my lord 24/1/2018. Because she did the search. She is the lady SI, she was dropped. Now, prosecution evidence are there, my lord. This will start from page 86. Witness PW1, he is also official witness. PW1 in the, I'm just reading the cross part, my lord. Cross part is page 87. Before we conduct the search on 3 suspected ladies, we never knew their description. Their gift box were made up of papers and same were not seized by police. See, he is a police, he is also one of the official witness. I have no knowledge how the IO of the case could have identified all 3 suspected accused. Before search, we never asked the accused person as to whether they wanted get themselves searched by gazette officers. The bags which were carrying gift box were not seized. I cannot say how much contrabands were seized from whom. At the time of seizure, on the spot, the seized contrabands were wrapped in a white paper. The paper is not seen today in the court. I have not seen any identification mark given in the seized contrabands. I was not a seizure witness to the seized contrabands during the seizures of contrabands to the magistrate was present in the spot. Also, the seizure of contrabands, no magistrate was present in the spot. Then this important is PW2. He is the IO. Only the IO implicated the appellants here in Malad. And more vital is Malad, this appellants were not produced after their arrest. They have not been produced before the magistrate also, as per section 52A. Even the contrabands were not brought to the magistrate, Malad. In their cross, he has admitted. Yes, my cross to the defense, page 89. I cannot disclose the source from whom I gathered the information cannot be disclosed. From the source, I could not have been gathered the name and identification of the accused. It is true that seized the contraband, lost the FIR and took up the case. Seizure was not made before the magistrate. All accused were apprehended as persistent by Lady Constable and their belongings were seized. It is true that after arrest, all accused persons, they were not brought before the magistrate. And I have separately sent the sample marked as exhibit, marked as A1, AB, and C1 to the SFL. There is the sampling, my lord. And the sampling also, there is no witnesses. And this sampling has to be identified through an magistrate, my lord, after taking contraband from the spot itself. That was not done. That's why, my lord, section 54A, 52A is lapsed. Then PW3, he is also one of the witness, my lord, seizure witness. I do not remember the date and time of offense, but on the day when I was in counter at rowing transport, the police seized opium from the accused who was standing on the dock today. On one more lady accused, exhibit M3 shown to me today in the court are contraband which police have seized before me from 3 ladies accused person. I have seized, signed the seizure memo, exhibit so are my signature. Here he said, but he has not signed the sample taken from this contrabands. Nobody has signed, only the IO has said. I cannot say in which seat of the bus all the accused persons were traveling on the date of alleged incident. I cannot say how much contrabands were seized from each accused person. No magistrate was present at the time of seizure. The seizure contrabands were weighed inside the APS counter. Then PW4, he is one of the independent witnesses. I cannot recognize both the accused person standing on the dock. I forgot the time, date, and year. But one day, when I, after breakfast, returned to bus station, I have seen all accused persons arrested by police. And then the police opened the boxes and seized some substance found inside the box. We were asked to sign on as a seizure witness, material exhibit so and so shown to me today are the same substance which the police has seized on the day of occurrence. P exhibit so and so is my signature. Now the cross melon is important. I have not seen the police seizing contrabands from the possession of any of the accused person. I put my signature as seizure memo at rowing bus station. And one more independent witness, PW5 man. I cannot recognize the accused person standing on the dock on the day of occurrence. When I passed through a crowd, I have seen the police with a gift package exhibits when so shown to me today are the same substance which police has seized before me. I have put my substance signature as one of the seizure witness. Cross minor. I have not seen from whom the police has seized the contraband. The contents of seizure memo was not read over to me. Then another is my lord, this scientific officer, this FSL report. There is not material. This are the my lord witness only. The vital witness, R does lady ASI. She was not the person who searched was not examined. To that effect, my lord, there is also judgment of our High Court is there, my lord. And also regarding my lord, section 52O. My lord, 2016 1 SC. Basically, paragraph 31 is the last conclusion. Is there. Paragraph 31, last page of the judgment. To sum up, we direct this under no sooner the seizure of any narcotics drugs or practice or control substance and conveyance is affected. The same shall be forwarded to the officer in charge of the nearest police station or to the officer empowered under section 53 of the Act. The officer concerned shall then approach the magistrate. He has not approached the magistrate. He admitted that I have not produced the accused and also contraventions were not countersigned by the magistrate. With an application under section 52A subsection 2 of the Act, which shall be allowed by the magistrate as soon as may be required under subsection 3 of section 52A, as discussed by us in the body of this judgment under heading of seizure and sampling. That is seizure and sampling, your lordship may find in paragraph 15. The sampling shall be done under the supervision of magistrate, as discussed in para number 15 and 19 of this order. The central government and its agency and also the state government shall within 6 months from the date of taking appropriate step to set up storage facility for exclusion storage of seized narcotics, drugs, psychoactives, and controlled substance and conveyance duly equipped with valves and double locking systems to prevent the theft, replacement of seized drugs. The central government and state government shall designate any officer of each of the respective storage facility and provide the other steps and measures as stipulated in Standing Order number 1 of 1989 to ensure proper security against the theft. This is not so important, my lord. Basically, 31(1) is important. The other is also there, my lord. This is the one, no? And one more is this 2011 SEC, para 5 and 6. There is sampling regarding sampling, paragraph 5. We find, however, that the second aspect on which the High Court has opinion call for interference as per the prosecution history, the sampling had been removed from the Malkhana. This is not so important. Next 6. We must emphasize the prosecution relating to the Act. The question how and where the sampling has been restored, as whether they have been dispatched or received in a laboratory in a manner great importance on account of huge penalty involved in the matter. The High Court was therefore, in our view, fully justified holding that sanctity of sampling had been compromised with the cause of doubt on the prosecution history. We therefore feel the judgment. So whatever sampling they have been taken, it has to be taken, keep in conscious manner in except custody. But in our case, it is not done. And regarding my lord, non-examination of witness, my lord, there is 2022. Yes, ma'am. 2022 5 GLT. This paragraph 17. Sorry, paragraph 19. Number. Paragraph 19. It is further noticed that in view of non-examination of any independent passenger witnesses who witnessed the accused carrying the bag with the train, ASI who allegedly first detected is ASI SK Jha, who allegedly first detected him carrying the contraband and reported the detention to the officer in charge of GRPF Guwahati, namely Inspector Polkumar, has certainly weakened the prosecution claim of recovery and seizure of aforesaid contrabands morphine from the exclusive and conscious possession of the accused. Here, Malot says, first, the NN Jha, who is one of the SK Jha, he was not examined. Like as my case, my lord. Therefore, my lord, there is a vital lapses in the prosecution and therefore, my lord, appellants were illegally convicted only because on the presumption that the books were recovered from them. It was not true, my lord. The person who did the search, two constables, one lady constable, one lady officer, they have searched. The only, my lord, the PW2 has contended it was seized from our possession. Other witnesses, independent witnesses they are totally silent. That's my answer.
Yes.
Lordship, here, Lordship, independent witnesses are there, Lordship, which they have examined, Lordship. And Lordship, they have, here, Lordship, IO, Lordship, is it not bad that IO cannot be a witness, Lordship? He could be Lordship, because Lordship, in the judgment also, Lordship, I'll peruse it later, Lordship. Here in,
We are
this.
hearing the matter as a whole, na?
Yes,
Lordship.
ma'am.
Criminal appeal.
Yes.
Yes, Lordship.
Only 5 witnesses are there. This way, ma'am. Whole matter may be destroyed.
As per Lordship, this 2021 1 SSC Lordship, it is held that the investigation by an officer which is informant and compliant is not barred under the NDPS Act. And same principles were reiterated to the subsequent judgment of Honorable Supreme Court in the case of Rijwan Kanwasi State of Chhattisgarh also. And also, Lordship, regarding the section 50 of NDPS Lordship, it is Lordship, it is for the Lordship, personal search Lordship. But here, Lordship, that personal search was done, their search was done in the public premises. So section 50 doesn't attract here, Lordship. In NDPS Lordship, section 50, here in comment, Lordship, it is stated that section 50 can be invoked only in cases where the drug, narcotic, NDPS substance recovered as a consequence of the body search of the accused. In case the recovery of narcotic is made from a container being carried by individual, the provision section 50 would not be attracted. Here, Lordship, the convict persons were Lordship, they have convicted Lordship. As per the Lordship, the substance were recovered from their body, Lordship. And this, as per the FSR report also, it is clear that opium is their Lordship. And regarding Lordship, as this, my senior, they stated that the CRPC 269, 263. It cannot follow that there some officers should be there to conduct that report, to make that report. But here, Lordship, in our state, Lordship, we send to the Bandar this nearest Lordship. Whoever is available there, they will make that all these necessary reports they collect, and they have sent us to here, Lordship. So there nothing less as such kind of officer is there as per the CRPC Lordship. So it is like that, this is going on till now. Independent witnesses, they are examined as per the deposition lordship, as PW 1, 2, 3 also lordship, they are all inside that said bus. They have seen that recovery done in front of them. And lordship, regarding the magistrate lordship, because this is such operation which is being informed by lordship, some they have that information could not be lordship revealed lordship by the information of this investigation officer. On the basis of that information, they have search was going on, search was conducted, and the recovery was done. And after that lordship, they have all the necessary thing they have done lordship. Only during the time of seizing lordship, the magistrate was not there because it is all of a sudden that was made. And that was in public premises also.
But in regards to 52A, what will you say? Most probably there is no compliance at all.
50, regarding the deposit process, any officer as cell as may be informed the ground for such arrest. Any arrested and says that under section they provide businesses to the magistrate. Lordship, date to lordship in this paperbook also not their lordship, so we could not go through all the records lordship.
It was not prepared.
No, it is there in the record, my original code. Even the seizure list was not signed by the magistrate. I have gone through the reports. The IO himself stated in his cross that accused were not produced before the magistrate after arrest. And regarding inventory as required under section 52A, subsection 2, that was also not done. The prosecution failed to prove beyond reasonable doubt, Your Worship. If it is proved beyond reasonable doubt, then burden will lies on me. One more judgment is there, man. This 2008-16 SSC. This is also important. Everything has been discussed regarding discrepancy, evidence, independent non-examination of this paragraph. Important paragraph is 58, 59, and 19 is the conclusion. 119 is a conclusion, last paragraph. Here, my lord, the 119, it is said, our aforementioned finding may be summarized as follows. Provision of section 34, 35, and 54 are not controversial of the Constitution. However, the procedural requirement laid down therein are required to be strictly complied with. My lord. The procedure has to be followed. They have not followed any procedure. Even the contraband which was seized was not produced before the magistrate. Not even his signature was taken. There is no exhibit. And that sampling was taken, sent to the SFL, was not signed by the magistrate. They have not been produced. And then third is there are large number of discrepancy in the treatment and disposal of physical evidence. There are contradictions in the statement of official witnesses. In my case also, there is a contradiction as earlier. PW1 says, I have not seen. The PW2 only said, IO. Non-examination of independent witnesses, nature of confession, and circumstances of recording of such confession do not lead to conclusion of appellant's guilty. Finding on the discrepancies, although if individually examined, may not be fatal to the case of prosecution. If cumulative view of the scenario is taken, the prosecution case must be held to be lacking in credibility. the fake of recovery has not been proved beyond all reasonable doubt, which required to be established before the doctrine of reverse burden is applied. Recoveries are not being made as per the procedure established by law. The investigation of the case was not fair. It is happened in my case exactly. Apply source. I'm basically section 52A.
Lordship, 52 Lordship 3, every person arrested and Article 6 under subsection 2 of section 41, section 42, 43, 44 shall be forwarded without necessary delay. The officer in charge of the nearest PS. That is done, Lordship. Only the magistrate was not there at that particular time because that is a sudden Lordship search. And Lordship, when the search was made in public premises, that 50 cannot be attracted. And Lordship, section 42, Lordship. 42 also the power of peace, dear Lordship, to entry, search, seizure, arrest without warrant or authorization. Section 42 of NDPS Act. May I read, Lordship? 1. Any such officer of the Department of this Excise, being officer rank in to a beyond require constable of the Department of this Central Excise, Narcotic, Custom, Revenue, and other department of central government, including paramilitary forces, empowered in this behalf by general or special order by central government. Any such officer of the officer superior rank to a beyond revenue, etc., department of the state government as is empowered in duty by general official order of the government. If he has reason to believe that personal knowledge or information given by any person taken on writing that any narcotic drug or psychotropic substance or controlled substance in respect of which an offense under this act can be committed, or any document or other article which may furnish evidence of the commission of such offense, or illegally acquired property, or any document or article which may furnish evidence of holding any illegally acquired property which liable to for seizure or freezing or forfeiture under chapter 5A of this act, kept consider any building, conveyed and made between sunrise and sunset. Enter into such any such building, conveyed or place in case of resident, break down any door and remove any obstacle to such entry. See such drug or substance or materials used in the manufacture thereof, and any article and any animal or conveyance which he has reason to believe to be liable to confiscation under this act, and any document or article which he has reason to believe may furnish evidence of the commission of any offense under this act, or furnish evidence of holding any illegally acquired property which liable for siege or freezing forfeiture under chapter 5 of this act. And detain such if he thinks proper, and arrest any person whom he has the reason to believe has committed any offense punishable under this act, provided that in respect of holder of license or manufacturer of the manufactured drugs or narcotic substance or controlled substance granted this act or rule made there under, such power shall be exercised by any officer not below the rank of sub-inspector. And also here, provided further that if such officer has reason to believe that a search warrant or authorization cannot be obtained without affording opportunity for the concealment or evidence ransom to escape from offender, he may enter such a building, convent or enclosed place of any time between sunset and sunrise after reporting the grounds of his belief. Where an officer takes down any information writing under such record for his belief under the review thereto, he shall within 72 hours send a copy thereto immediate officer. So Lordship, it is complied, Lordship. And Lordship, and some minor discrepancies in descriptions are there, Lordship, but evidences are, Lordship, it is there that the recovery is done, Lordship, in the public press, and from the concise recovery, Lordship, concise position is there. My Lord, I am conclude my here, Lordship. If I, Lordship, I submit the related case law, Lordship, regarding where this section 50, Lordship, is not attracted in this appeal. Yeah, Lordship, these things happens in their side, Lordship. Usually opium, Lordship, is there are lots of like, because we cannot say this is Lordship as a very big crime, because in their Lordship custom also, they used to take Lordship.
That is the prevailing custom there.
And
Coffee
there-
cultivation is also.
We try to Lordship save people from these things, but the people, they are more enjoying having this Lordship. Bless Lordship.
Applied.
Anyway, 17. So it's not yet arrived. Let each matter be listed, huh? What has happened?
It's on Monday.
Monday, lots of matters are like so. And list after 2 weeks. 2 weeks. What happened in council?
She called me and she told me that she was preparing last night.
Kutia was there. no?
Yes, madam. She was preparing last night and she could not get up by 9:30. That's the reason she is staying in
She
Nahalagan.
stays where she stays.
Nahalagan.
Nahalagan.
Yes, madam. So that
From
was
where she has to come by?
by road,
No,
she
by-
don't have a private vehicle, so that's the reason she has to take a lift
Oh,
from someone. So she has asked someone to pick her up, it seems, but they couldn't make it.
today weather was.
Yes,
better,
madam.
so